things that our community encounters is that we're used, maybe growing up, I grew up in Jordan, and there was a lot of situations where the marriage may not necessarily have been documented in court. You know, like here in the United States, almost every marriage has to go through court. It's documented. There is a marriage certificate. But a lot of times, you know, you'll have maybe members of our community or from different community. They come to this country and they have a marriage that's called مثلا زواج عرفي or a religious marriage. How do we navigate these marriages? Are they recognized in the United States? What is the best way to protect ourselves if we have that kind of marriage?
Okay, so yes, that is a popular thing that a lot of us Arab have, is we are only married religiously, and that's perfectly fine. That's nothing to be afraid of. New York State is a common law marriage state, which means that it recognizes a religious ceremony as a valid form that unites two people together as a married couple. So oftentimes when we have a religious ceremony, we do a Katb Kitab ceremony. And as everybody knows, in Islam, a Katb Kitab requires a sheikh who marries two people. Usually it's the groom, the aris, and his bride, who has a wali. Mm-hmm. And there are witnesses. There's usually two witnesses, and both the aris and arus sign the Katb Kitab papers. And this is considered a contract, a legal binding contract in the United States, specifically in New York State, because it's got witnesses, it's got signatures, and it's got parties of sound mind who are voluntarily and willingly marrying each other. So although for people who are only married religiously, although you didn't take the step of going to New York City Hall to get married in front of a clerk, you are considered an actual married couple in the eyes and the courts of New York State with just a religious contract.
Rami, no.
Thank you for that. And before I move on to my next question, actually something came up today when we spoke. Ayat and I worked together at an office. Allah yarhamu Ustaz Mustafa. Ayat is one of the people he trusted, and so I was a friend of his, and subhanAllah, the circumstances brought us together in the same office. So one of the things we were talking about today, not just marriage that could happen without paperwork, sometimes even divorce can be done without documentation. Can you tell us more about that, and what are the ramifications of that, and what are the ways to protect ourselves if that's the situation, if somebody comes in and tells us that's what they're encountering?
So the tricky part about the marriage, the topic of marriage and family law in general, is that every case is a fact by fact basis. So you can't give general advice based on a general story. Every different detail requires a different answer. But if somebody wants to get a divorce and not document it, then my first question would be, well, how are they married to begin with? Were they only married religiously? Or were they married in City Hall? I mean, before I answer that question, I'd need a few facts.
So our next topic, one of the things people always ask us as well, even Aman as a lawyer who doesn't really necessarily practice family law, you always have consults or people who are desperate for information. Mainly, if somebody wants to do what's called a prenup or setting condition for marriage, or it's totally different how we grew up in our countries than in the United States. What are the ways that people could set conditions on the marriage, whether before marriage or even after marriage?
Okay, absolutely. So there are conditions you can set before marriage. That's called a prenuptial agreement. And there are conditions you can set after marriage called a postnuptial agreement. Now, before I talk about postnuptial agreements, I'm going to start with prenuptial agreements. As a matter of fact, in our deen, in Islam, the Katb Kitab is considered a prenuptial agreement. So we're going to start there. So if you were to go statistically, I would say 99.9% of the Muslim world, of the Muslimin who are married, already have prenuptial agreements. Because what is essentially a prenuptial agreement? It's an agreement between the prospective husband and wife who are coming together and setting conditions on the marriage before they actually agree to consummate the marriage. Now, what are those conditions? In the Kitab, it's usually obvious. In order for a man to marry a woman, he has to give her mahr, which is a bridal gift. That bridal gift is actually the consideration. So he offers for her, to be his wife. She accepts it, and then in order to validate that, he has to give her the mahr, which is the bridal gift, and then that makes the marriage a valid contract. Now, so the mahr is one part of this prenuptial agreement, and then oftentimes people have what they call mutakhir, which is a debt on the husband, and it basically says that this debt is owed on by the husband onto the wife, and oftentimes we see that it's given in the case of a divorce. So that in itself is a form of a prenuptial agreement. Now, in the American culture, things are taken probably 100 steps further. Every single situation you can possibly think of can be put into a prenuptial agreement. Other than the mahr and mutakhir that we normally do in good faith, you can go as far as putting an infidelity clause, which means that in the case any party cheats on the other, or commits adultery, there is a certain condition that's set. For example, if adultery is committed, you get divorced. But not only do you get divorced, you take something from that, or that person's not allowed at something else. Other things that could be included in a prenuptial agreement is, for example, oftentimes you see a man is well established in his work, and he comes from wealth, and he has businesses, and he owns buildings. And lots of times in the Arabic world, we all know that men tend to have these buildings maybe with their brothers or their father, and they want to make sure that in the case of a divorce, their wife can't take any of this because technically he shares his wealth with other people and other family members. And so a prenuptial agreement would be smart in that case to make sure that in the case of divorce, the wife knows she's not entitled to perhaps the husband's background wealth or anything he may own, or his businesses that he came into the marriage with, but maybe she's only entitled to, let's just say, the mutakhir that they agree to. So there's plenty of reasons to have a prenuptial agreement. And in the case that somebody's already married and you don't have a prenuptial agreement, but you think that conditions as that would be helpful or beneficial for you, you can always do a post-nuptial agreement, which means you do the same kind of contract, but you can do it after you're married. So you can sit and have a meeting of the minds with your husband or your wife, and you can say, hi, I've put together this contract or this paper, and I'd like to sign it because I think it's beneficial for us so that we don't fight over things in the case of a divorce. Because everybody knows, unfortunately, people may love each other during the duration of their marriage, or they may be reasonable minded, but during a divorce, for some reason, we're human, we tend to get spiteful. So to avoid that, you can do a post-nuptial agreement. I hope that answers your question, Rami.
Oh, no, it absolutely does. Thank you. It's extremely helpful. And, one of the, I want to stay a little bit, talk about the prenups, because a lot of times it's like a taboo subject matter, because people don't want to bring it up, and they'll say, oh, I trust you, I love you, we're coming into this marriage. We don't need any paperwork, we don't need anything like that. How do you, what do you advise people who have, this situation going on where, they trust each other, they love each other, it's true love. It's just one party wants something written and the other party does not. What's your advice for them?
My advice would be to always approach it from an honest, good faith perspective. You can always you have the deen on your side. You have Islam on your side. Like I said, it is the sunnah to actually have what we call a prenuptial agreement. It is embedded in our culture. We think we don't have it. We think it's taboo, but really we're already practicing it for thousands of years now, hundreds of years. So you can use that as a basis and say, look, we're already doing it through our kitab. Let's just add a few more details, and you can also just try to be open with your fiance or the prospective spouse, and you could say, I share my wealth with my family, and I trust you and I love you, but just to protect everybody around us, it's not just about us. Let's have an understanding so that we don't get into problems later. You can also, my advice is give your assurances in other ways. You know, you can do a prenuptial agreement where you're making your spouse feel like you're taking something away from them, but you're also giving them something else in return. Say, you may not be entitled to my business, but in case anything ever happens, I promise to give you this. So it's kind of a give and take. That would be my advice. Try to approach it from just an honest, good faith perspective. And you, like I said, use the deen.
Okay. And I know you've answered this already, which is the difference between common law marriage and like a civil marriage. And feel free to always bring that subject matter up as we talk, because it's just so helpful for people, because they don't really, because, you know, it just comes in different circumstances and it's kind of like plays in differently. So feel free to just like chime in with that as we go. I also just want to welcome a lot of the staff from Mustafa's office, you know, Abraham and Madiha and Yassine. My other question, I want to talk about, you know, let's say a couple are, you know, have hit a turn in their marriage where they think this is not good for them, or they want to seek divorce. What are the legal steps that they can take?
Well, the first thing you want to do is figure out how they're married. So I'm going to take the assumption that they're married both Islamically and civilly. Yeah? So they're in City Hall and they have their Katbat Kitab. Because as we know, the majority of shuyukh in today's times actually require that you have a City Hall certificate before they sign the Katbat Kitab for you to avoid any problems with the state.
I'm sorry for interruption. I just want to clarify something. Like, we don't only talk about Islamic marriage. Like, there is marriage in like a lot of Arabs are Christians. They marry in the. So let's make it more broad when we talk. That's all.
So I'm going to talk about it from the perspective of both civil and religious. So the first steps you'd have to do if you feel that your marriage is crumbling down and it's coming to the divorce, you want to first take a look at your assets. You know, do you own anything in the marriage? Do you and your husband, or do you and your wife have a house? Do you have any properties? Did you buy these properties while you were married? You know, first see if there's an entitlement upon a divorce that your spouse would have half of what you own. Right? And then after that, you want to sit and actually have a discussion with your spouse, because the majority of the time in New York State, if you're married to somebody, New York follows laws of equitable distribution, which means that if you acquired something during the duration of your marriage, more likely than not, it's subject to 50-50 split, which means half goes to, you know, each spouse. And oftentimes people want to try to fight that in court, but they find that it becomes an uphill battle that lasts several years sometimes, and it never makes anybody happy. It only brings out the worst of people. So my advice would be to, you know, if you feel like you're about to get a divorce, think about what you have at stake. Do you have any children? Is there any money? Are you, you know, what kind of salary are you making? And sit with your spouse and discuss a reasonable way to divide what you think is a fair and appropriate share to give your spouse, and try to settle things. Try not to go to court. Nobody wants to be in court. It's probably biased for me to say this because lawyers would be out of a job, but I still will say it. Do not go to court. If you can avoid it, do it by all means. So what you want to do is you're only going to be filing for a divorce with an attorney, but you're going to be ending things quickly, and it's going to be what we call an uncontested divorce. Why? Uncontested means you're not fighting over things. Why? Because you probably already agreed to stipulate to a lot of things in a settlement agreement. If you, for whatever reason, cannot find a way to settle, what you want to do is, you know, go to an attorney, figure out if there are any assets, and figure out if there are any children. And then you have to see which spouse or which parent the children are going to live with. Rami, I don't know how detailed you want me to get. Again, actually, it depends on a hypothetical.
So yeah, I was thinking if we can go through like an actual example.
Yeah.
That way we can answer the questions about the property and the children and the division of property and premarital property and the postmarital property. So let's say, you know, a couple A and B, They could be of any sex, they could be of any religion, you know, it's just A and B, and they intend to divorce. They have property that they had before marriage, they had property that they acquired after marriage, and they have 2 children. And so now couple A and B want a divorce. How would it go under the New York law at least?
Okay, so point blank, any property that was acquired before the marriage remains the property of the spouse who acquired it. It is not subject to equitable distribution, which means subject to 50-50 split. So that's said and done. Any property or assets acquired during the marriage is subject to equitable distribution, which means that we'll now have to determine at what point during the duration of the marriage this property or asset was acquired. So let's just say this couple that you're talking about that has property with 2 children, let's just say the husband bought a building 6 months into the marriage. Technically speaking, that was property that was acquired during the marriage, but it was acquired very early on in the marriage, which means that there's an argument that could be made as to whether the money that he used to purchase that building he had already in his bank account before the marriage. So there are ways to determine that. If he bought this building, let's just say 10 years in, then it's hard or difficult to believe that he had that money 10 years ago. He probably acquired it during that 10 years, which means his wife is entitled to half. So same goes for the woman. You know, if she purchases something during the marriage and it's deep into the duration of the marriage, the husband is entitled to 50% of it. Lots of times when couples are getting a divorce, oftentimes one or the other will ask the person who's making more money in the marriage upon a divorce to pay alimony or spousal maintenance to the person who's not making as much money or maybe not making any money at all. That's also something we determine during the process of equitable distribution. So for example, in this scenario that you gave, Rami, I'm going to just be stereotypical and say the husband is the moneyed spouse and the wife is at home with the 2 children. Let's just say the husband is a doctor and he makes a very good salary. He makes $400,000 a year. So we would take a portion of his salary to determine how much money he should give his wife upon a divorce monthly, so that she could أسرف حالها. The argument is that if the wife had been reliant or dependent on the husband all of those years, she can't just reasonably expect to go find a job immediately upon a divorce and أسرف حالها or spend on herself immediately. There has to be a reasonable amount of time for her to get on her own 2 feet, so the husband would have to continue to pay this spousal support every month until she's able to do so. So in this case, if they were married for 10 years, we would typically just estimate that he would be expecting to give her spousal support for 5 years until she's able to get on her own 2 feet. Usually, an estimate. We usually go and cut the duration of the marriage in half, and we'll go by that. In terms of the children, in family law, it all goes back to the best interests of the child. That is the most important thing that the courts will always look at. Every judge and every attorney is going to focus on what is the best situation for the children. So in this particular case, you know, you have a husband who's a doctor, he's the father, he's making a lot of money, the mother is not. So you would think the best interest of the children would be to go with the father because he has the money to take care of them. But that not necessarily may be true, because he may be putting in very long hours at his work. And the children are probably used to staying with the mother, and the mother knows she handles all their doctor appointments, she handles all their school and academics, and so they're reliant on her. It also goes back to their age, if they're very young versus if they're older teenagers. So that usually in that scenario, the best interest would be to remain with the mother because they're used to staying with the mother, and the father would pay then child support, which would also be calculated based on his salary. That's very brief. That was very brief.